Hello and welcome to the second video in our series Unpacking the Key Rules and Requirements in relation to cost budgeting. Today we start off firstly looking at, well, what does a cost budget actually look like? In terms of the form of the cost budget, unless the court otherwise orders, then it must be in the form of Precedent H annexed to Practice Direction 3E. The first page of the budget, the front sheet, looks like this. You can see it's set out in relation to different phases of the proceedings, and it draws that distinction between incurred and estimated costs, further split down in relation to disbursements that have been and will be incurred, and the profit costs that have been and will be incurred. In a later video, we'll go into more detail as to the different elements of the budget. That is only the front page of the budget. It's supported by further pages which set out the different costs in relation to each particular phase. It's not within the remit of today's video to look at that in detail, but I do encourage you to go and look at Practice Direction 3E and the Precedent H which is appended to it in order to familiarise yourself with the workings of the budget and how it's laid out. What other requirements are there in relation to form and content of the budget? Well, it must be dated and verified by a statement of truth signed by a senior legal representative. As with all elements of the rules in relation to budgeting, it's an important requirement. It's essential that it is signed with an appropriate statement of truth, otherwise you will risk or take the risk of a sanction applying with the effect that you're treated as having filed a budget limited only to the applicable court fees. Again, that will be relatively disastrous, therefore it is essential that we keep an eye on these particular issues. For the statement of truth itself, it changed several years ago now, so do make sure that you're using the correct statement of truth and aren't using any outdated templates. The statement of truth currently required, as we sit here today in May 2020, is that this budget is a fair and accurate statement of incurred and estimated costs, which will be reasonable and proportionate for my client to incur in this litigation. What additional requirements are there? In cases where a party's budgeted costs don't exceed £25,000 or the value of the claim as stated on the claim form is less than £50,000, then the parties must only use the first page of Precedent H, so not the supporting documents or supporting pages which go behind it. It's slightly unusual. Clearly the parties in the court will have less insight as to how those costs are broken down, what they're intended to be spent on. We would suggest generally that whilst you may need to only file and serve the front page, that when you prepare budgets, you prepare it as normal, you complete all those supplementary and supporting documents in order that when you get to a CMC, if the judge, as they likely will, asks for more information as to how the costs are calculated or why it is that they're running at a particular level, you'll be well placed to give them all the information they might reasonably require. What does the budget cover? Unless the court has made a specific direction which limits the budget to only part of the proceedings, then it does need to include all costs up to and including final resolution of all issues at a contested trial. Even if you feel almost certain that that case will settle without trial, for instance, by way of ADR, it's essential that you do include all of those costs. Again, if you don't, firstly, it might be determined that you can't recover those costs that you haven't included, even if they do later become necessary. But as a more of a worst case scenario, it might enable your opponent to argue that if you've left out phases within your budget or costs that you do anticipate will be incurred, then it may be open to them to argue that actually your budget itself is non-compliant and therefore sanction applies, again with the effect that you're limited to having filed or treated as having filed and served a budget limited to only applicable court fees only. Again, disastrous outcome, so make sure you do include everything. In some cases, the court does have a power to direct that parties' budgets are limited initially to part only of the proceedings. It can subsequently extend them then to cover the entirety of proceedings. And this is a useful power for the court. There's lots of occasions and situations in which you may feel that despite budgeting applying per the rules to your case, You may feel that in the specific circumstances that it's actually inappropriate for that case to be budgeted or for it to be budgeted at that point in time. Your client's prognosis, for instance, may be particularly uncertain in a particularly complicated case, and you might consider that budgeting would be an unsafe exercise to undertake or engage in at that time. Do be aware though, again, parties can't unilaterally limit their budgets, so if you do consider that it's necessary or sensible for the court to only budget part of the case, they need to obtain that order from the court. We'd recommend that you seek the cooperation of your opponent and potentially seek orders by consent limiting budgets to part only of the proceedings, or putting them off until some more convenient or appropriate time in that litigation. In terms of the budget and the phases, well, as we've seen, it's broken down into several phases which are intended to represent the entire process of a claim. So in terms of phases, there are phases for pre-action costs, those incurred in relation to issue statements of case, case management conferences, disclosure, witness statements, expert reports, the PTR, trial preparation, trial, alternative dispute resolution, and there's also provision for contingencies. There is a guidance note, again, available on the Court Service website, which I would encourage you to consider and familiarise yourself with. The practice direction to 3E was amended again a few years ago to give that note greater importance and authority. So paragraph 6B of practice direction 3E was introduced to provide that parties must follow the precedent age guidance note in all respects. Again, it's not within the remit of today's session to look at the specifics of that guidance note. That's something that we'll come back to in later sessions when we're going through the nitty-gritty of the budget and how it's laid out and how we'd suggest that it ought to be prepared. It does, though, give us pause for thought just as a general idea. So I come to the contingent cost sections, and the guidance note makes this comment in relation to contingencies. The contingent cost sections should be used for anticipated costs which do not fall within the main categories set out in this form. Examples might be the trial of preliminary issues, a mediation, applications to amend, applications for disclosure against third parties, and so forth. Costs which are not anticipated but which become necessary later are dealt with in paragraph 7.6 of practice direction 3E. And I then return to the underlined aspect that I skipped over them, in that only include costs which are more likely than not to be incurred. So this is part of the guidance note in relation to contingencies. As a general proposition, I'd suggest that it gives an element of guidance as to how you should go about preparing budgets generally. I would seek to dissuade people from putting too much in their budget, from taking the worst case perspective possible of all elements, so making unrealistic assessments of what might happen in that litigation simply because you want to try and protect yourself, or putting or estimating that things will take far too much time beyond that which they're reasonably likely. Judges generally won't like that approach. It will make it more difficult for you to get your budget agreed between the parties, or for the court to make an assessment that you think is reasonable. If we start with an outlandish budget, then in all probability the court will feel like it has to start again from the ground up, rather than simply looking at your budget and assessing it. So I do encourage people to be very realistic and sensible about the estimations they make, but also we do have to bear in mind again that it's got to include everything that you anticipate will happen. We have this direction in relation to contingencies, that they should only include costs which are more likely than not to be incurred, and that seems to be a pretty sensible way of approaching budgets generally. Of course, making clear to the parties in the court what is anticipated to happen and what potentially isn't, if that's relevant and not obvious from what you've said will happen. The guidance note reminds us that costs which are not anticipated but which become necessary later are dealt with in paragraph 7.6 of PD3E. We talked in the last video about the apprehension and fear factors around budgeting. Certainly that desire or need to put in to the budget all costs which could possibly occur in a case is fairly understandable, because we don't want to later find that we can't recover costs simply because they weren't included in the budget. But again, the key is to make sure that it's sensible and reflects what is likely to happen. Because per paragraph 7.6 of PD3E, the door isn't completely closed once your budget has been set. It is possible for the court later to review it and change it and revise it upwards and even potentially downwards in particular cases. So per paragraph 7.6 of PD3E, each party shall revise its budget in respect of future costs upwards or downwards if significant developments in the litigation warrant such revisions. Such amended budgets shall be submitted to the parties for agreement. So just pausing briefly again to unpack this rule, there's a reference to a need to revise budgets if significant developments in the litigation warrant those revisions. We'll come back in later videos to discuss what exactly constitutes a significant development. The purpose of drawing your attention to this at this time is just so that you can keep it in your mind that it is a relatively fluid process. It's a fluid process with a lot of risks in it and a lot of hurdles to overcome, but it isn't the case that you have your budget set once and it can never be changed. Another point to flag up at this point, even though we're very early in this video series, is that the amended budget should be submitted to the other parties for agreement. If you want to vary your budget, again, it's necessary to send it to the opposing party before you actually ask the court to make a determination on it. Only if the other party or if the parties between them can't agree the revision should it then be sent to the court. Paragraph 7.6 of PD3E goes on to say that in default of agreement, the amended budget shall be submitted to the court together with a note of A, the changes made and the reasons for those changes, and B, the objections of any other party. Clearly, in order to be able to comply with that requirement, the other party needs to have been given sight of that amended budget first and request or asked to provide details of their objections. Once those steps have been taken, and assuming there's not been any agreements in relation to revision of the budget, it's sent to court, and the court can then either approve, vary or disapprove the revisions, having regard to any significant developments which have occurred since the date when the previous budget was approved or agreed. So it's a very important rule in itself, because it is one of the things which builds into the regime the element of flexibility which is required in order to make it workable. It's an important reminder that things can be changed, but of course we do have to bear in mind all the relevant steps and the rules as we're discussing them. Paragraph 7.9 of PD3E also flags up another interesting issue in relation to interim applications. Your budget will set out and assume and plan for and estimate the way in which you believe that case will run. It's often the case in many claims that there will be hitherto previously unanticipated interlocutory applications. Paragraph 7.9 provides that if interim applications are made which reasonably were not included in the budget, then the cost of such interim applications shall be treated as additional to the approved budget. Again, unpacking that rule, it's essential that we bear in mind and observe the reference to applications which reasonably weren't included in the budget. This isn't a blanket provision enabling all applications to stand outside budgets. If you anticipate the need to make a particular application at the time that you're preparing your budget, and you think it's more likely than not that you're going to have to make that application, then we recommend that you do include those costs within your budget. If it's entirely speculative, then you can probably safely rely on this provision, but you'll always have to have regard to the specific circumstances of your case, the arguments and issues that you're addressing, and what you expect your opponent to come back with. This has all been very interesting, of course, but it sounds like it's giving rise to a lot of costs and a discrete and new aspect of costs, which is preparation of the budget and management of this budgeting process itself. What happens in relation to those costs? We turn for that to point 9 of the Preston H guidance notes, which says that in relation to budget preparation, the time spent in preparing the budget and associated material must not be claimed in the draft budget under any phase. The permitted figure will be inserted once the final budget figure has been approved by the court. When we looked at the front page of that budget, we'll see that the various phases were set out, and then at the bottom there were boxes in which the 1% and 2% allowances could be included. So subject to some other points that we'll make when we come to go through the guidance notes in detail, budget preparation and management shouldn't be in the body of the budget itself. It should just be indicated in those percentage boxes on the front page. What about the amounts of those costs? What about the fees? Is there any restriction or break upon those costs, given that they are a new creature, a new beast once budgeting have been introduced and are additional and different to costs that we used to see incurred prior to introduction of budgeting? Well, per paragraph 7.2 of Practice Direction 3E, save in exceptional circumstances, the recoverable costs of initially completing Preston H shall not exceed the higher of £1,000 or 1% of the total of the incurred costs as agreed or allowed on assessment and the budgeted costs as agreed or approved. And secondly, all other recoverable costs of the budgeting and cost management process shall not exceed 2% of those figures. So pausing briefly to just unpack that a little, it is the case that it's effectively a movable feast. Your budget is prepared originally, and it includes the full extent of the incurred cost that you have already incurred and the full extent of the future cost that you expect to have to incur. When it comes to working out how much you can recover in relation to the 1% and 2% allowances, you'll see that can't actually be fully determined until the court has approved or assessed your budget for future costs. And also it can't be determined until the very end of the case, until the incurred costs have either been agreed between the parties or approved by the court, because it's 1% and 2% of those reduced figures rather than the sums as originally claimed. So that's an important point to bear in mind as well. That concludes our video today. This is the second video in the series. We'll be coming back again shortly to continue going through this process of unpacking the rules and the specific requirements or the key requirements in relation to cost budgeting. I look forward to presenting to you again, and stay safe.